This is Constitutional Rights in Black and White.
One morning in 1956, Louise Lassiter went to the general store in Northampton County, North Carolina, to register to vote. Now, in order to register, Lassiter had to pass North Carolina's literacy test. Specifically, she had to read and write a section of the state constitution to the satisfaction of the registrar. The registrar was Helen Taylor, whose husband owned the general store. Taylor gave Lassiter a copy of the state constitution to read. Lassiter mispronounced a few words, and Taylor rejected her application to vote. Now, over the years as registrar, Taylor rejected around half of all black voter applicants, although she rejected only one white applicant. Lassiter's story came to the attention of a local civil rights lawyer named James R. Walker, one of only 26 black lawyers in the whole state of North Carolina at the time. And he filed a class action lawsuit on behalf of Lassiter and all other plaintiffs, challenging the legality of the literacy test. They made a number of arguments. They argued that the test had a grandfather clause, which is a statute that permitted white males to vote even without a literacy test. They also argued that the test gave too much discretion to registrars like Taylor. He maintained that the test was being used in a racially discriminatory way to disenfranchise black people in North Carolina. And then finally, they argued much more broadly that the literacy test was itself an unconstitutional burden on the right to vote. The lawsuit struck a nerve among the political elites of North Carolina. The literacy test was a central tool of white supremacy. It permitted North Carolina to exclude most black voters from the voting rolls. It was also a symbol of state sovereignty and resistance to federal oversight. So in reaction to this lawsuit, the state legislature tweaked its voting laws. It eliminated the grandfather clause, which even at that time was clearly unconstitutional. It deleted the language giving registrars unfettered discretion, but it kept the literacy test. As a result of these changes, the lower federal court refused to strike down the new law. It also found no race discrimination, concluding that the literacy test was applied by the registrar to white persons and Negroes alike without discrimination. Now, Louise Lassiter and James Walker, the lawyer, they needed a new legal strategy. So Lassiter went back to the registrar's office. This time, she refused to take the literacy test. She argued that it was invalid, void, and unconstitutional educational test. She was denied the right to vote, and she sued again. Her case went before the United States Supreme Court, where she argued that North Carolina's literacy test violated her fundamental right to vote. No, it doesn't, said the court. You have the right to vote, but that right is regulated and constrained by state law. When the Constitution speaks of the right to vote, it refers to the right to vote as established by the laws and Constitution of the state. And states have wide latitude. The states have long been held to have broad powers to determine the conditions under which the right of suffrage may be exercised, absent, of course, the discrimination which the Constitution condemns. But wait, said Miss Lassiter, this is a democracy. My right to participate in elections is fundamental. Local laws and local registrars should not be able to take it away. Otherwise, I don't really have the right to vote at all. Well, you have the right to vote, said the court, but a literacy test is a permissible restriction on that right. Its establishment is but the exercise by the state of a lawful power vested in it, not subject to our supervision. And literacy tests are not irrational. In our society, where newspapers, periodicals, books, and other printed matter canvass and debate campaign issues, a state might conclude only those who are literate should exercise the franchise. This is a trick, said Miss Lassiter. Everyone knows that literacy tests in North Carolina are overwhelmingly enforced against black people, that literacy rates are lower among black people, and that the entire point of the literacy test is to keep black people from voting. Well, said the Supreme Court, if you could prove all of that, it would be a different case. But that was not your case, and you have not shown discriminatory racial enforcement here. You haven't shown intentional race discrimination. And the North Carolina law itself does not discriminate on its face. Literacy and illiteracy are neutral on race, creed, color, and sex, as reports around the world show. Wow, said Miss Lassiter. So you're saying that as long as North Carolina does not openly discriminate on the basis of race, it can create as many restrictions and barriers to voting as it likes, even when the obvious effect is to disenfranchise black people? Basically, yes, said the court. Lassiter versus Northampton was an early voting rights case when the law was changing very quickly. Just a few years later, in 1964, in Reynolds versus Sims, the Supreme Court explicitly recognized that voting is a fundamental right because it is preservative of all rights. The Voting Rights Act of 1965 outlawed literacy tests, but Lassiter is still a crucial case because its reasoning reveals deeper problems with our voting rights jurisprudence. The Lassiter court deferred to the state and the state's authority to regulate the franchise because it held this is the way that our Constitution designed it. And it is still the case today that the Constitution allocates authority to the states. The Lassiter court reasoned that absent race discrimination, partisan political interference with access to the ballot is constitutional. And of course, today, this same reasoning applies and permits the states to make it hard for millions of people, especially, but not only black people, to vote. Perhaps most fundamentally, the Lassiter court reasoned that states can decide, through legislation and regulation, who does and does not deserve the right to vote. This reasoning still pervades the court's jurisprudence, and it is still inconsistent with a modern, functioning democracy. In other words, Lassiter still has enormous contemporary significance. Okay, now, let's read the case. Lassiter versus Northampton represents a forgotten but crucial chapter in the American civil rights saga. Louise Lassiter was a black woman in the rural South in the 1950s before the passage of the Voting Rights Act, otherwise known as the VRA. By then, North Carolina had effectively disenfranchised almost all of its black citizens. The lawyers were also emblematic of the time. Lassiter's attorney, James Walker, was a local lawyer who initiated the case against the advice and without the support of the national NAACP, because Lassiter's lawyer believed that his community needed it. He was one of the many unsung local foot soldiers who helped make the way for the VRA. North Carolina's lawyer, I. Beverly Lake, was a segregationist who had filed a brief in support of racial segregation in Brown v. Board just a few years earlier. The case had a twisted history. Lassiter tried to register several times and was denied because a local registrar, Helen Taylor, decided that she was insufficiently literate. Walker filed a lawsuit in federal court on Lassiter's behalf. In order to preserve the literacy test, the North Carolina legislature superseded the old voting rights statute with a new, more easily defensible version. Lassiter then went back to the registrar and strategically refused to take the literacy test on the grounds that it was unconstitutional. That lawsuit is the one that ended up in the Supreme Court. Before reaching the merits, the Lassiter court had to dispense with the remnants of the state's grandfather clause. The original grandfather clause excused from the literacy test any male person who could vote before 1867 and all their lineal descendants. Before 1867, prior to the passage of the Reconstruction Act and the 15th Amendment, only white men could vote. So grandfather clauses were used in many southern states to preserve the franchise for whites while excluding black people. In 1915, in a case called Gwynn versus United States, the Supreme Court recognized that grandfather clauses are racially discriminatory and struck them down as a violation of the 15th Amendment. The 15th Amendment, which was passed after the Civil War, states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. In Lassiter, North Carolina conceded that the old grandfather clause was invalid. But since North Carolina had revoked the clause, the court held that it had no bearing on the current literacy test. This is a good place to start unpacking the central and limiting role of race and the Lassiter court's reasoning. On the one hand, grandfather clauses are unconstitutional because they denied the right to vote on account of race. But once that overt tactic was eliminated, the court treats it as entirely separate, or as the court puts it, separable from the rest and void from the tactic of the literacy test, even though they were born out of the same discriminatory motivations. Indeed, the court entirely ignores the intimate connection between low black literacy rates and racial discrimination in public education. This was so even though just 5 years earlier the court recognized in Brown that black people were being systematically deprived of educational opportunities. The court then moves on to the merits. Whether a state may consistently with the 14th and 17th Amendments apply a literacy test to all voters irrespective of race or color. The question embodies the court's general approach to the franchise. The Constitution divides authority for voting rights law, policy, and enforcement among three different institutional players: the Supreme Court, Congress, and the states. This structural arrangement privileges the states as the primary actors in developing voting rights law and policy. From the court's perspective, Lassiter was thus an easy case. In Gwynne, the court had already upheld the idea of the literacy test itself, absent the discriminatory grandfather clause, and the Lassiter court repeats Gwynne's language. No time need be spent on the question of the validity of the literacy test considered alone, since, as we have seen, its establishment was but the exercise by the state of a lawful power vested in it, not subject to our supervision. That lawful state power turns out to be the heart of the matter. As the court immediately elaborates, the states have long been held to have broad powers to determine the conditions under which the right of suffrage may be exercised. Notice what this means for American democracy. Under this model, voting rights are effectively a function of state law and practice. The Constitution delegates broad authority to the states to regulate and administer the franchise. As the court writes, while the right of suffrage is established and guaranteed by the Constitution, it is subject to the imposition of state standards which are not discriminatory. In other words, the right to vote refers to the right to vote as established by the laws and Constitution of the state. We have the right to vote, but it is almost entirely mediated through state law, which means that the states get to decide who deserves to vote and under what circumstances. The court emphasizes that the state still may not discriminate on the basis of race, but this constraint turns out to be quite limited. Lassiter's lawyers had neither the resources nor the ability to prove racial discrimination, even though everyone knew it was rampant. Indeed, it was the entire point of the literacy test in the first place. But because the court accepts the formalistic assertion that literacy and illiteracy are neutral on race, creed, color, and sex, the state is constitutionally free to impose such restrictions. More fundamentally, the Lassiter court makes clear that the only basis for breaching state sovereignty is state racial discrimination. Without a showing of racial discrimination, states can do pretty much whatever they like. The Supreme Court has persisted in this deferential reasoning over the decades. There are few constitutional constraints on the states with respect to their regulation of the franchise. Those constraints are based on a limited set of negative prohibitions, such as the prohibition against sex discrimination by the 19th Amendment or race discrimination by the 15th Amendment. These are elastic and they're easily manipulable because there are no meaningful structural limitations on the power of the states to regulate the franchise. States have endless ways, which many states continue to put into practice to this day, of undermining the franchise. It might be tempting to write off Lassiter as an old and quaint case like a rotary phone. Since Lassiter was decided, the Supreme Court has created a far more robust doctrine of voting rights. Literacy tests have been banned by the Voting Rights Act of 1965. However, Lassiter is no relic. The deeper reality of American democracy is that we do not have a standalone fundamental right to vote as a privilege of our national citizenship. Rather, we only have the right not to be discriminated against based upon characteristics like race or gender when we vote. To put it differently, the opportunity to disenfranchise is built into the structural design of our Constitution. This is because the Constitution does not guarantee voting as a fundamental right, and because the framers chose to delegate to the states the manner of exercising the vote and the content of voting qualifications. Bottom line here is that as long as the state does not discriminate based on race or similar characteristics, it can burden, constrain, and interfere with the right to vote in myriad ways, including the right of black people to exercise the franchise. Today, those structural decisions are more pressing than ever. The Supreme Court has rolled back the scope of the Voting Rights Act, and that rollback is part of a larger political sea change in which the civil rights consensus that brought us this far, and for which Louise Lassiter worked so hard, that consensus is dissolving. Claims of racial equality no longer capture the same kinds of shared constitutional, political, and moral imagination that they once did. America no longer agrees that we need to actively address our historical and current practices of racial exclusion. And these changes are playing out at the state level in the form of new voter restrictions, where many states are actively interfering with the voting process through redistricting, registration rules, voter purges, absentee ballot restrictions, and other mechanisms that prevent many Americans, especially black people, from voting. But differently, the deep issues of discrimination through a state-controlled franchise that the Lassiter Court failed to confront are still haunting us today. Ms. Lassiter's voting rights saga thus reveals a deep feature of the American democratic crisis, and it is this: the biggest threat to the franchise is unrestrained state power.
Many, many thanks to my colleague, Professor Guy-Uriel Charles. He is the Charles J. Ogletree Jr. Professor of Law at Harvard Law School, where he also directs the Charles Hamilton Houston Institute for Race and Justice. Professor Charles is a leading scholar and nationally renowned expert on election law, race, and democratic theory. We're fortunate that he took the time to share his work and his insights with us.